Okay, welcome back, everyone. We're going to go ahead and get started with our next panel. Joining us here today is our esteemed regulators from the SEC Chicago Regional Office. They're going to be talking to us today about securities regulation from a federal perspective. Joining us here virtually are Tina Diamakopoulos, who's the regional director, Lou Gracia, who is the assistant regional director over the exam program, and then Catherine Piszka, who is the associate regional director over enforcement. Let's go ahead and get started. Tina, I'm going to start with you. You're new to the regional director position, but certainly not new to the SEC or to the Chicago regional office. Can you share with us some of your background and other roles that you've held within the SEC?
Good morning, everyone. Good morning, Janice. Before we begin, I must give the following disclaimer that my presentation and remarks today are provided in my official capacity as the Regional Director of the Chicago Regional Office of the SEC, but do not necessarily reflect the views of the Commission, the Commissioners, or other members of the staff. I also want to make the same disclaimer for my colleagues. Kay Piszka, in her official capacity, is an Associate Regional Director for Enforcement, and Lou Gracia, in his official capacity, as an Associate Regional Director in Examinations. So with that disclaimer out of the way, I'd like to thank you, Janice, David Beamel, and Commissioner Site, as well as Case Western University, for inviting me and my colleagues to participate in your program today. And we really thank you for bearing with us to appear virtually this year. We appreciate it. We would rather be there in person. Hopefully the next time that'll be the case. And if you're hearing me okay, I will just go ahead and continue to answer the question, Janice. Looks like you are. Okay, great. So I've had the privilege of working at the SEC for my entire legal career. I began with the Chicago office as an intern during law school and was then hired as an enforcement attorney through our advanced commitment program. It's now known as the Chair's Attorney Honors Program, and I know there's some students in the audience, so I highly recommend internships as well as a career in the government. I spent the first 10 years in the enforcement division, 5 of those years as an attorney, and 5 of those years as a branch chief in enforcement, where I supervised a group of attorneys in investigations and litigation. At the same time, I was eager to understand the industry we regulate and how it works. And so while I had worked on several examinations, referrals, and investigations, I also then pursued a position in the exams program. I wanted to see how our firms work, how our markets work, how they're structured, and how compliance back office functions work as well. And for the most part, it was encouraging for me to see how most registrants want to comply with the securities laws and how we work with the SEC to achieve it. But as we all know, the reality is that we do find deficiencies, and sometimes these deficiencies can pose a serious threat and harm to retail investors and the securities markets. In 2010, I had the opportunity to be counsel to the regional director. That gave me insight not only into the investigations and the exam work that the office does, but it really allowed me an opportunity to work and lead on policy initiatives, as well as work with management and on personnel and operations issues. I had the privilege of serving for 4 great regional directors for 12 years. And then in 2022, I was excited to return back to the exams division as an associate director for our broker-dealer program. And then this past May was named to the regional director. So really grateful for the opportunities I've had to work both at the SEC, but also wanted to mention to this audience to work with a lot of you from the state of Ohio, law enforcement, U.S. attorneys' offices, and other regulators and partners in Ohio over the years.
That's great, Tina, and we're happy to work with you as well. We have a great working relationship, and very glad that you're joining us here today. The SEC is not a monolith. Like any entity, it's more than the sum of its parts, especially one that has so many different divisions, units, and offices. Looking at the Chicago regional office, how does it fit into the SEC as a whole?
Great, yeah. So we are one of 10 regional offices across the commission. We're the SEC's second largest office. And we primarily conduct enforcement and examination activities. Our region includes alphabetically the states of Kentucky, Illinois, Indiana, Iowa, Michigan, Minnesota, Missouri, Ohio, and Wisconsin. We have approximately 350 employees in the Chicago office now. That's comprised of lawyers, accountants, examiners, financial analysts, economists, data scientists, paralegals, IT specialists, and other important operations personnel. But the overwhelming majority of the Chicago regional office staff are in two programs. In our enforcement and exams program, we have about 95 people in enforcement and about 145 on the exam staff. That's broken up mostly by about 45 in the broker-dealer program and 100 in the investment advisor and investment company program. But the reason we also have such a high headcount in Chicago is we have a lot of national employees from the commission that are based within our office. They come to us from different divisions, including exams and enforcement, but also the Office of Clearing and Settlement, the Technology Control Program, the Private Fund Unit, the Office of General Counsel, and others. So what's really nice about that is that presence has grown over the years, and it really helps to complement the regional work. It allows us to sort of collaborate and work with others across national programs, even just being down the hall in our office. Just to give you a little perspective, the Chicago office's backyard is really a large dynamic market. New York has the largest exchanges, mostly down even the street, but our office oversees key financial intermediaries like the Options Clearing Corp, key exchanges like the Chicago Board of Options Exchange, and has the largest number of branch offices and registered reps in the country. So specifically, we have 2,500 registered investment advisors, over 5,800 private funds, 170 registered investment companies, as well as fund administrators and transfer agents that we cover.
Great, thank you, Tina. I'm going to turn now to Lou. I know we have private practitioners in the audience and virtually, as well as folks from firms and compliance that are interested in examination. So Lou, I'm going to turn to you. Last week, the Division of Examinations released its exam priorities for fiscal year 2025. Any areas or changes that you'd like to highlight?
Yeah, great. Thanks for the question. Happy to highlight. Yeah, it's well timed this event in that our exam priorities that we put out every year, and that we've been endeavoring to get out as early in our fiscal year as possible. We have accomplished that again this year in that getting those out. I think it was just last Monday actually when they technically got published. So let me share with you. I mean, it covers a lot of areas. So and certainly I would encourage everyone to read those. But I can highlight a few things that I think would be important, especially in the investment advisor space and overall. So, for example, one of the areas that we're certainly going to be concentrating our exam efforts are on higher risk products and strategies. So, in particular, investment advice provided to clients regarding products with particular focus on high cost products, unconventional instruments, illiquid and difficult to value assets, and assets sensitive to higher interest rates. So, for example, commercial real estate and derivatives of real estate. We'll be concentrating on the advisor's compliance programs. We may focus and go into greater depth on the actual practices and the products being used. And so, for example, if clients are invested in illiquid or difficult to value assets, we will have a heightened focus on valuation. Some of the other areas, and some of this stuff you'll have seen in the past, so some of it is repetitive, but we learn more and more about this areas, and we take little nuances of it. So conflicts of interest, this is a perennial for us. We almost always be looking at conflicts of interest. So in particular, we'll be looking at the impact on advisors, conflicts of interest in providing impartial advice and best execution with consideration given for non-standard fee arrangements. Certainly looking at fee arrangements, the appropriateness and accuracy of fees, continues to be a focus of ours. We continue to find issues in that space, and so we will definitely be looking at it further. Also looking at areas of alternative revenue sources. So areas in which may be focused is revenue or benefits to advisors that they receive, such as selling non-securities based products to clients. We'll also be looking at firms with operations with heightened risk. So if an advisor utilizes a large number of independent contractors working from geographically dispersed locations, certainly our exams will focus on the supervision and oversight practices of those branch offices, if you will. And lastly, specifically IAs, marketing will continue to be a focus, but I know we're going to talk about that a little bit later. And then just really quickly, a handful of areas that kind of go across investment advisors, investment companies, broker dealers, and all the other registered entities that we deal with. One would be cybersecurity. Again, very much a perennial risk of ours. And so we will definitely be continue to kind of look at cybersecurity practice by registrants, particularly paying attention to the firm's policy and procedures, governance practices, data loss prevention, access controls, account management, and responses to cyber-related incidents, including those related to ransomware attacks. Again, we will be looking at another area. We'll be looking at the shortened settlement cycle, the T+1. In particular, obviously, that is going to be a significant interest on broker dealers and exchanges. But there is a part for investment advisors as well, as advisors do have to have some new books and records requirements and some policy and procedures. So we will definitely be looking at that angle at advisors. And then lastly, or second to last, actually, crypto assets. So obviously, given the volatility and activity involving crypto asset markets, we're going to continue to monitor and when appropriate, do exams of registrants that are offering crypto asset related services. We'll primarily be focused on the offer, sale, recommendation, advice, trading, and other activities involving crypto asset securities. And then lastly, AI. We couldn't say that we're doing anything new and interesting if we weren't going to say that we're going to look at AI. And so we have already begun to do some reviews in that area, and we will be continuing to look at that. In particular, looking at how AI is impacting the advisor's operations, including portfolio management, trading, marketing, and then looking at their policy and procedures and disclosures. In particular, an interest in the disclosures of the use of AI match the advisor's actual practices.
Great. How does the SEC develop their exam priorities?
Yeah, so it very much is a ground up approach. So individual exam groups out there in the regions and in headquarters collect information about new or trending risk. Each office and program kind of does it maybe slightly different. I can tell you for Chicago, we start that process as early as February, and really we are gathering ideas from examiners, from our exam managers, and other stakeholders. Most of those ideas, quite honestly, are born out of the exam work and come from, like I said, all levels of managers or all levels of staff. We hold a brainstorming session where we collect those ideas and then gauge. We then, ask staff to kind of gauge which ones they believe are more important or that they have a particular interest in. We kind of select what we think are the best ideas that national exam programs should put in consideration for the exam priorities. My understanding is the National Exam Program actually obviously collects all those ideas across all those programs and then begins to draft them, obviously with input from other stakeholders up into including the chair and the commissioners.
Great, thank you. And Lou, I know the examination program there is doing great things, including obtaining financial remediation as part of examinations. And that means that exams result not only in update of business practices to ensure compliance, but also a reimbursement to affected clients in some cases. In what situations does the SEC seek remediation, and how do you determine what the appropriate amount of that should be?
Yeah, and it is something that we're continuing to do we think our efforts to get firms to remediate from the exam process is in many ways advantageous to clients. It's more immediate, and spares everyone from having to have a matter go to enforcement, and so we certainly seek those remedies when appropriate. So I kind of think of it in a couple of broad-based situations in which we will be seeking remediation. Though first and foremost, those instances in which clients have been directly harmed. So, for example, fee error or miscalculations, trade errors, or some form of undisclosed compensation that the advisor received. So for examples, we have seen instances in which advisors have failed to properly apply breakpoints in their fee arrangements, included unmanaged assets in the fee calc, failure to give accurate credits for 12B1 fees or other types of revenue sources. On the private funding side, certainly I've seen expenses that were ineligible for reimbursement, but they were reimbursed. And then obviously failures to get best execution, especially when utilizing an affiliated broker dealer. We've also seen some instances in where it's more the fact that the advisor failed to meet its duty of care. So, for example, selection of the less advantageous share class for clients, RAP fee clients being charged for a transaction cost in addition to the RAP fee that they paid, and then recommending unsuitable investments which incurred losses. So, in determining what's the right amount to get reimbursed, we honestly look for the advisor to really conduct that analysis and determine the reimbursement. We will often, though, still we ask the advisor to give due consideration to the breadth and extent of the issue, making sure to include all affected clients and to cover the period in time for as long as the conduct had been going on. We also advise advisors that they should consider the application of interest on calculating their reimbursement amounts. But with that, we recognize that there can be limits to how far back in time the advisor can reliably determine the reimbursements, and the possibility of relatively small amounts on a per client basis. So it's important that the advisor should kind of lay out for us the parameters and limitations in their methodology. This way, then we'll have a clear understanding as to exactly how they came up with the remediation amounts. The other thing we advise is in determining how the reimbursement should be made. They should be clear about exactly how that's going to be done, whether a direct payment or fee credit or some other mechanism. And we also look for an advisor to let us know exactly how are they going to notify clients of this. We would strongly encourage that notice be in writing to those affected clients, and it clearly outlines the issue, the need for reimbursement, and the explanation of the methodology that was employed.
Thank you, Lou. And I think we'll turn now to enforcement, a cause that's near and dear to my heart, of course. Kay, next question is for you. What the recent end of fiscal year 2025, are there any recent enforcement matters, particularly those originating in your office in Chicago, that you think are particularly impactful?
Yeah, thank you. So our office has brought a number of impactful cases during the last year, and some of them were against Ohio-based individuals and companies. So I'm just going to highlight a few of them. First, I'd like to talk about our off-channel communications matters. Since December 2021, the Division of Enforcement's continuing sweep to ensure that regulated entities, including broker-dealers, investment advisors, and credit rating agencies, comply with their record-keeping requirements has resulted in charges against more than 100 firms and over $2 billion in penalties for failures to maintain and preserve electronic communication. Excuse me. So the division's investigations in this sweep uncovered pervasive and long-standing uses of unimproved communication methods, including personal text messages, known as off-channel communications by employees of broker-dealer and investment advisor firms. The firms did not maintain or preserve the substantial majority of these off-channel communications in violation of the federal securities laws. The firms were ordered to pay significant penalties, to cease and desist from future violations of the relevant record-keeping provisions, and were censured. They also agreed to retain independent compliance consultants to, among other things, conduct comprehensive reviews of their policies and procedures relating to the retention of electronic communications found on personal devices. We participated in this sweep of off-channel business communications cases, with our Chicago teams bringing 13 of these cases against some of the largest registrants in our region, including Ohio-based duly registered broker-dealer and investment advisor, Key Investment Services LLC, as well as KeyBank Capital Markets Inc., who together agreed to pay a $10 million penalty. So moving along, the Chicago office staff also brought some of the first cases to enforce regulation best interests. Tina's going to be talking more about these cases and the work of our broker-dealer examination staff in this area later, but I'll mention one of them now because it involves Key. In May, the commission brought settled charges against Key Investment Services LLC for its failure to address conflicts of interest in violation of Regulation Best Interest and the Investment Advisors Act. Key agreed to a cease and desist order, a censure, and a civil penalty of $223,000. According to the SEC's order, between June 30th, 2020 and February 2022, Key failed to comply with Regulation Best Interest and the Advisors Act by recommending, through its registered representatives and investment advisor representatives, that certain of its brokerage customers and advisory clients transfer securities from Key accounts to new investment accounts with Key's affiliate, Key Private Bank, a wealth management firm that's part of the same parent organization, without disclosing that the representatives would receive compensation for making the recommendations and for any securities transfer, and therefore had a conflict of interest. The order further found that Key Investment Services' written policies and procedures were not reasonably designed to achieve compliance with the disclosure obligations under Reg BI and the Advisors Act with regard to conflicts of interest associated with the recommendations to transfer securities out of Key brokerage and investment advisory accounts to investment accounts held at Key Private Bank, or to identify and address the associated conflicts of interest. Again, another case involving an Ohio company, the Chicago office staff in the division's Public Finance Abuse Unit also filed 2 actions arising from a multi-year political corruption scheme involving First Energy Corp., an Ohio publicly traded company, and its former CEO, Charles E. Jones. As described in the commission's settled order against First Energy and alleged in the related litigated complaint against Jones, the parties engaged in a years-long corruption scheme in which First Energy paid bribes to former Speaker of the Ohio House of Representatives, Larry Householder, in exchange for official action benefiting First Energy's business interests. When the scheme was revealed, First Energy and Jones made misleading statements to investors about their roles in the corruption. The commission's settled order against First Energy found that between 2017 and 2020, First Energy and affiliates made approximately $60 million in payments to a 501c4 entity controlled by Householder in exchange for specific official action for the benefit of First Energy and affiliates, including Householder's support in passing certain nuclear legislation. In July 2020, Householder was arrested in connection with his role in the scheme. The SEC's order found that following his arrest, First Energy and Jones made a series of misrepresentations to investors about First Energy's role in the political corruption scheme. Additionally, the order found that First Energy failed to disclose material related party transactions with regard to payments First Energy made to a 501c4 organization funded and controlled in part by certain former First Energy executives. First Energy consented to a cease and desist order, finding it violated the anti-fraud reporting, internal controls, and books and records provisions of the federal securities laws, and agreed to pay a civil penalty of $100 million. And then the litigated complaint against Jones alleges he participated in, and in some instances directed the bribery scheme. It further alleges that when the scheme was revealed, he misled investors when he characterized First Energy's actions as ethical and transparent, and that as part of the scheme, he lied to First Energy's auditors and filed a false certification. That complaint alleges that Jones violated the anti-fraud provisions of the federal securities laws and Exchange Act Rules 13A14 and 13B22A, and aided and abetted First Energy's violations of the reporting and internal controls provisions. It seeks injunctive relief, disgorgement plus prejudgment interest, a civil penalty, and an officer and director bar against him. I'd also like to talk just a bit about the recent cyber cases brought by Chicago office staff in the division's crypto assets and cyber unit. Earlier this week, the commission charged 4 current and public companies, Unisys Corp, Avaya Corp, Avaya Holdings Corp, Checkpoint Software Technologies, and Mimecast Limited, with making materially misleading disclosures regarding cybersecurity risks and intrusions. The settled administrative proceedings against the 4 companies resulted from an investigation involving public companies potentially impacted by the compromise of SolarWinds Orion software and by other related activity. According to the SEC's settled orders, Unisys, Avaya, and Checkpoint learned in 2020, and Mimecast learned in 2021, that the threat actor likely behind the SolarWinds Orion hack had accessed their systems without authorization, but each negligently minimized its cybersecurity incident in its public disclosures. The SEC's order against Unisys found that the company described its risks from cybersecurity events as hypothetical, despite knowing that it had experienced 2 SolarWinds-related intrusions involving exfiltration of gigabytes of data. The order also found that these materially misleading disclosures resulted in part from Unisys's deficient disclosure control. The SEC's order against Avaya found that it had stated that the threat actor had accessed a limited number of the company's email messages when Avaya knew that the threat actor had also accessed at least 145 files in its cloud file sharing environment. The SEC's order against Checkpoint found that it knew of the intrusion, but described cyber intrusions and risks from them in generic terms. The order charging Mimecast found that the company minimized the attack by failing to disclose the nature of the code the threat actor exfiltrated and the quantity of encrypted credentials the threat actor accessed. The SEC settled orders found that each company violated certain applicable provisions of the Securities Act of 1933, the Securities Exchange Act of 1934, and related rules thereunder, and each company agreed to desist from future violations of the charge provisions and to pay penalties in amounts ranging from $990,000 to $4 million. Finally, last but not least, the Chicago office also brought or settled significant gatekeeper cases. So gatekeepers, including accountants, auditors, and other professionals, share responsibility for protecting investors, and they're often the first line of defense against misconduct. When they don't live up to their obligations, investors, market integrity, and the public trust all suffer. So in May of this year, the Chicago office brought a settled administrative proceeding against an audit firm for one of the largest ever wholesale failures by a gatekeeper. In a settled administrative proceeding, the commission charged audit firm BF Borgers CPA PC and its owner, Benjamin F. Borgers, with deliberate and systemic failures to comply with Public Company Accounting Oversight Board, or the PCAOB, standards in its audits and reviews incorporated in more than 1,500 SEC filings from January 2021 through June of 2023. The SEC also charged them with falsely representing to their clients that the firm's work would comply with PCAOB standards, fabricating audit documentation to make it appear that the firm's work did comply with PCAOB standards, and falsely stating in audit reports included in more than 500 public company SEC filings that the firm's audits complied with PCAOB standards. The SEC's order found that the respondents engaged in improper professional conduct and violated and caused violations of the anti-fraud, record-keeping, and other provisions of the federal securities laws. To settle the SEC's charges, BF Borgers also agreed to pay a $12 million penalty. Benjamin Borgers agreed to pay a $2 million penalty, and both respondents agreed to a cease and desist order, censure, and permanent suspensions from appearing and practicing before the commission as accountants. Finally, going back to Ohio-based individuals and entities, earlier this month, the commission issued a settled administrative proceeding against Horder Investment Company, LLC, a Cincinnati-based investment advisor, and Drew Horder, Horder Investments founder and CCO, for failing reasonably to supervise Kim Hannon, an investment advisor representative that had been associated with Horder Investment. That settled order found that from at least November 2015 through at least March 2017, Hannon misappropriated $728,000 from Horder Investment clients purportedly for his outside business activities, but instead he used those funds to gamble, pay personal expenses, and repay other investors. The order further found that Horder Investments' overall supervisory structure was inadequate to reasonably supervise its investment advisor reps generally, and Hannon specifically. The order found that Horder Investment failed to establish supervisory policies and procedures and failed to follow those procedures that it had in place. Horder Investment also failed reasonably to follow up on red flags. The order further found that similarly, Horder himself, who had overall supervisory responsibility for Horder Investment, failed to follow specific policies and procedures, failed reasonably to supervise Hannon, made open-ended delegations of supervisory responsibility without following up, and failed reasonably to follow up on red flags. Pursuant to the settled order, Horder Investment was censured and ordered to pay a civil penalty of $100,000, and Drew Horder was also ordered to pay a civil penalty of $50,000 and to serve a 6-month supervisory suspension. And Hannon is currently serving a 20-year prison term following his January 2019 conviction for Ohio State securities law violations, arising in part from his misappropriation of funds from Horder Investment clients.
Thank you, Kay. And that's a case that's near and dear to my heart as well, because I was the attorney that handled that case and investigated that Kim Hannon case. It was an interesting case, start to finish. There were 9 victims, about $1.6 million that he took from these victims. Very interesting. The first trial was pro se, and in the course of after he was indicted, he actually sent a business plan to me, to the forensic accountant at the Attorney General's office, to a magistrate in Stark County with a business proposal for rolling file cabinets. And it had a logo and a business proposal, and he only asked for 3 things. 1, he wanted us to drop the criminal charges. 2, he wanted to have monthly meetings with all of us to get the business up and running. And then 3rd, he wanted a monthly income of $7,000 to keep the business running. So there was a little bit of.
Did you invest, Janice?
I was asked it on the stand. No, but it was a nice result. The victims were happy in that particular case. They lost a lot of money. They were elderly. These were retirement funds that these victims had. So he was sent to prison for 20 years. Release date is 2038. And I think the investors would have liked to get their money back. It's nice that the SEC, it was a nice example of collaboration because we were both doing kind of what we do best. And the SEC went after the firm because they had oversight and they should have been supervising Mr. Hannon. And then, of course, we investigated and prosecuted criminally. So it was a great example of cooperation. And Kay, this is an often discussed topic amongst the Securities Defense Bar and their clients. Are there any other recent cases that you think demonstrate the benefits of cooperation in an enforcement investigation?
Yes. Am I still on? Sorry, can you guys still see and hear me? I lost my own video. Okay, great. Yeah, so there were a number of cases recently where companies meaningfully cooperated with the division's investigation, and the commission credited that cooperation through no penalties or reduced penalties. In late September of this year, the SEC charged a registered investment advisor, Adam Investors, and registered broker-dealer Qualist with failing to maintain and preserve off-channel communications. Both received no penalty resolutions based on their self-reporting, remediation, and other cooperation with the SEC's investigation. And 2 additional brokers, dealers that were involved in those matters, self-reported their violations and as a result, paid significantly lower civil penalties than they would have otherwise. In another example, earlier in September of this year, the SEC announced settled fraud charges against tech company. It's CIRCOR. I'm going to just call it CIRCOR for material misstatements about the company's financial performance. As described in the SEC's order, the SEC did not seek a civil penalty against CIRCOR because CIRCOR self-reported its issues to the SEC shortly after commencing an internal investigation and thereafter provided substantial cooperation to the staff, including summarizing interviews of witnesses located outside the United States and making CIRCOR employees and external forensic accountants available for interviews. CIRCOR also promptly implemented remedial measures, which included strengthening its internal and accounting controls, hiring additional experienced finance and accounting personnel, and canceling compensation to be paid to a former executive officer. And then going back a little earlier last fiscal year, in February 2024, the Commission announced settled accounting fraud charges against Klupin Group Holding Limited, a China-based provider of cloud communications products and services whose shares formerly traded on the New York Stock Exchange. According to the settled order, 2 Klupin managers orchestrated a fraudulent scheme to prematurely recognize revenue. As a result of this misconduct and other accounting errors, Klupin overstated its financial results and revenue guidance for several quarters. According to the order, within a few days of starting an internal investigation, Klupin self-reported the accounting violations to the SEC and subsequently provided substantial cooperation to the staff, including summarizing interviews of witnesses located in China and identifying and translating key documents. Klupin also implemented prompt remedial measures, including firing or disciplining the people involved in the fraudulent scheme, reorganizing the departments engaged in the misconduct, strengthening its accounting controls, and recruiting new finance and accounting staff with expertise and generally accepted accounting principles in the United States. The SEC determined not to impose civil penalties against Klupin in light of the company's self-report and cooperation.
That's great. Thank you, Kay. I think we'll turn next back to Lou. So Lou, it's been some time since the commission adopted the new marketing rule for investment advisors. It's therefore no surprise that the Division of Examinations, I'm sure, has looked into registered compliance with this new framework. Are there any interesting takeaways from these exams?
Yes, absolutely. We have a number of interesting takeaways that come from it. So first, I would be remiss if I didn't recommend we put out a risk alert back in April of this year on specifically on our initial observations regarding the marketing rule and advisors' compliance with it, which discusses primarily issues that we've uncovered regarding the compliance rule, books and records, Form ADV, and general prohibition. But I can almost assure you that we are very likely to issue other risk alerts in the near future that will cover our findings regarding other aspects of the marketing rule, including the use of testimonials and endorsements, performance advertising, and third-party ratings. So certainly look for those to come out as the year progresses through the end of this calendar year and going into next calendar year. So, but with that, I do want to I would love to point out some of the things that we have noticed, some deficiencies that we've noted, and that might be a help for you to understand. So among some of the findings we've had are statements of material fact that the advisor was unable to substantiate upon demand, and in some cases were misleading or simply untrue. So, for example, false statements declaring that the advisor is free of conflicts. I can assure you, we found conflicts. So that became a false statement very quickly. Untrue statements about the number of staff employed by the advisor. Again, a firm that maybe had 1 or 2 professionals, not the teams or significant groups of experts that they intimated in their advertisements. Untrue statements about the staff's qualifications. We're talking about false credentials, false degrees, that they have college degrees and the like that they've had that or that they claim they had that they did not. Awards that they received that again they did not receive. Untrue statements about the services or products are offered. Again, we've seen instances in which there's an explanation of a particular service or a product in particular that they have an expertise in, and it's not even one that they truly offer or that they really have any expertise in at all. Untrue claims of the receipt of certain awards and accolades, especially those that are the most prominent and issued by true third parties. Misleading claims about the significance of certain endorsements. So when the endorsement was actually based on subjective factors, largely unrelated to the advisor's investment experience or success. So meaning some endorsement from some party or some organization that essentially they either paid for or merely needed to fill out a survey, self-proclaiming certain attributes, and thus received that endorsement or award. So, and then obviously a whole host of misleading statements about the advisor's business and the performance. Even so far as we've found advisors who have included the SEC logo on their website with the purposes of kind of inferring that the website or the advisor has been approved or endorsed by the SEC, which is never the case. And so those are some of the highlights. You will read see more of those, especially coming out in the risk alerts when we start to address some of those other areas. Really quickly, because I know I just want to mention some of the ones that involve performance. So we have found instances where performance doesn't use the proper fee calculation in it, meaning using a lower fee than actually is attributable to actual client services, using a benchmark that is really either not fully disclosed or maybe may very well be not appropriate given the nature of the investment strategy that it's being compared to. And then obviously other disclosures concerning about the methodology of how the performance calculations were done. And so they'll give you a little bit of taste about what we're kind of seeing in the marketing space.
That's bold to use the SEC logo, isn't it?
Yeah, I was surprised to think that someone thought that was, but it has. And so you can imagine when we confront them with that one, they kind of fold quickly.
I can imagine. Low hanging fruit. Oh.
Yeah.
So we have about 15 minutes left. So let's turn now to Reg BI. It's been about 4 years since the effective date of regulation best interest. And it has significantly enhanced the Commission's regulatory tools for addressing broker-dealer misconduct. Your office has been at the forefront of investigating Reg BI violations. Can you highlight some recent enforcement actions in this space?
Sure, Janice. So as Kay mentioned, and you've just mentioned, Chicago, the regional office, both from the exams program and the enforcement program, has really been leading the way with regulation best interest. The exact date that it became effective was June 30th of 2020, and it significantly enhanced the Commission's regulatory tools for addressing associated persons' misconduct involving retail investors. The details of the framework have been repeated many times since its enactment in speeches and lots of additional resources, including FAQs, staff bulletins, a risk alert. So I won't go into the details, but if you go to our website, there's a lot more detail available. In short, Regulation Best Interest established a best interest standard for conduct for broker-dealers and associated persons when they make a recommendation of any securities transaction or investment strategy to a retail customer. In the interest of time, I'm going to mention some of our cases that originated with examinations from our exam program, and then were also filed as actions in enforcement. I'll give a little bit of detail, but again, make sure to highlight the names since we're running short on time. So on June 16th of 2022, the SEC charged Western International Securities, Inc. with violating regulation best interest when they recommended an unrated high-risk debt security to retirees among other retail investors. This case originated from our exam program and was the Commission's first case charged under regulation best interest. It highlighted two parts of regulation best interest, namely a registered reps and a broker-dealer's care obligation and compliance obligation. The case was recently settled. Basically, the complaint alleged that between July 2020 and April 21, Western and its registered reps recommended and sold speculative illiquid securities called L bonds to retail customers, many of whom were on fixed incomes and had moderate risk tolerances, despite the issuer stating that the L bonds were high risk, illiquid, and only suitable for customers with substantial financial resources. Among the allegations in the complaint was that the defendants failed to comply with Reg BI's care obligation, both because they did not exercise reasonable diligence, care, and skill to understand the risks, rewards, and costs associated with the L bonds, and also because they recommended L bonds to at least 7 particular customers without a reasonable basis to believe that these bonds were in these customers' best interest. There's other allegations as well, but I'll move on to just make sure that we highlight some of the other cases for you. In another Chicago office case on September 22nd, 2023, the SEC reached a settlement with the firm of Carl M. Hennig for violations of regulation best interest. The complaint there alleged that between June 30, 2020 and January 23, Hennig's written policies and procedures were not reasonably designed to achieve compliance with regulation best interest. According to the order, among other things, Hennig's written policies and procedures did not explain what factors or criteria should be considered and weighed when making recommendations or determining whether a particular recommendation is in the customer's best interest. They didn't provide sufficient information regarding the information provided to customers, including the fees associated with Hennig's retail brokerage services, or address how and when Hennig would update and provide written disclosures to its customers. And in addition, Hennig's written policies and procedures did not explain how to identify conflicts of interest or how to disclose, mitigate, or eliminate them as the rule requires. So Western was the Commission's first case. It was litigated, then settled. Hennig was the SEC's first settled regulation best interest compliance case. Kay mentioned KeyBank earlier. A couple more recent cases, I'll skip through some others that are available as well, is that last month on September 18th, the Chicago office and the Enforcement Specialized Complex Financial and Instruments Unit helped bring an action against registered broker-dealer First Horizon Advisors, Inc. This case also came out of the Chicago office's broker-dealer program. The SEC charged First Horizon with structured note Reg BI compliance obligation violations. First Horizon migrated more than 5,000 customer brokerage accounts to its system from that of a broker-dealer with whom First Horizon had merged. And because of incompatibilities between the two systems, First Horizon did not have accurate customer information necessary to review the structured note recommendations for compliance with First Horizon's Reg BI policies and procedures. In addition, the registered reps who joined First Horizon from the merging broker-dealer also did not have access to First Horizon's exception reporting site to review structured notes transactions flagged as non-compliant, as was required by First Horizon's Reg BI policies and procedures. And First Horizon approved structured note recommendations without all of the documentation required by its Reg BI policies and procedures. And so without admitting or denying the SEC's findings, First Horizon agreed to a cease and desist order, a censure, and a $325,000 penalty. We also recently filed a settled administrative proceeding against State Farm VP Management Corporation. In its settled order, the Commission found that the firm violated regulation best interest when it, 1, recommended the State Farm 529 savings plan to certain customers who did not reside in Nebraska and who could forego tax benefits provided by their home state's qualified tuition programs. 2, recommended the purchase of Class A and Class P mutual fund shares to customers who had expressed short-term investment horizons or liquidity needs. 3, did not establish written policies and procedures that were reasonably designed to identify and address conflicts of interest and material limitations associated with these recommendations. 4, failed to disclose material limitations of securities available on its platform and its resulting conflicts of interest in recommending investments in the State Farm 529 savings plan and mutual fund offerings to certain retail customers. And finally, the commission found that the firm did not include required information about the material limitations of certain securities that recommended to retail customers and the resulting conflicts of interests in its form CRS in violation of Exchange Act Section 17A1 and Rule 17A-14. To settle the matter, the firm agreed to a cease and desist order, a censure, and to pay a $211,000 penalty. It's also important to note that in January of 2024, the firm also voluntarily paid approximately $422,000 to reimburse its affected customers. The last case I'll mention is just earlier this month. On October 2nd, we instituted administrative and cease and desist proceedings against Thrivent Investment Management, Inc., a Minnesota-based broker-dealer and investment advisor, for failing to comply with Regulation Best Interest. These charges were in connection with the registrant's recommendation that certain retail brokerage customers invest in Class A mutual fund shares, which charged upfront sales charges and annual fees, instead of Class C mutual fund shares, which did not impose upfront sales charges, but charged higher annual fees for the first 10 years of the investment, offered by the Nebraska 529 Savings Plan and the Illinois 529 Savings Plan. The complaint alleged that between June 30th, 2020 and July 22, Thrivent and its registered representatives utilized a 529 college savings plan share class calculator to determine which mutual fund shares to recommend, and that while historically it may have been in the best interest of many of Thrivent's customers to invest in Class A shares of the Nebraska and Illinois 529 savings plans, the two 529 savings plan made changes to their expense structures in March of 2020 and December of 2020, respectively, that significantly reduced the annual fees charged on the Class C shares. And so until July 2022, Thrivent failed to update its calculator to account for these expense structure changes. And as a result, Thrivent and its registered reps failed to exercise reasonable diligence, care, and skill when recommending investments in the 529 savings plans of Nebraska and Illinois. We also noted that they failed to establish, maintain, and enforce written policies and procedures reasonably designed to achieve compliance with Regulation Best Interest, and as a result, Thrivent failed to comply with Regulation Best Interest care obligation and compliance obligation in violation of the general obligation found in Rule 15/1A1 under the Exchange Act. Thrivent paid $220,000 in remediation to 846 retail customers to reimburse their upfront sales charges plus interest. They also consented to the entry of an order imposing a cease and desist order, a censure, and a $25,000 penalty.
That's great. We have about a minute left, and I'll ask this question to any members of the panel. What, professionally speaking, keeps you up at night? What practices, programs do you think pose the most risk to investors?
So I'll go ahead and kick it off and maybe leave 30 seconds for Kay and Lou. But honestly, in the short amount of time we have, I can say that technology really worries me. I feel like it obscures and amplifies a lot of the risks that we see for retail customers. And, there's been a lot of reporting on the gamification of trading. It's a real recent trend. Game-like elements such as rewards, competition, interactive features that are built into financial applications. And it does worry me that this approach is aimed to motivate users in their investment activities by drawing inspiration from themes found in video games or in other parts of social media, gaming videos. I feel like it can really encourage instant gratification over long-term sound financial objectives. So if I had to name one thing, I think it would be that. Cybersecurity worries me as well. And also financial intermediaries that look like they're a registrant, like a broker dealer, an investment advisor, an investment company, or even a bank, but that they don't operate as such. So as a result, people are handing over their investments, their savings, and they're not receiving basic customer protection or safety in their investments that they would otherwise receive. Maybe we're even out of time. Apologies. I think that was 2 minutes.
Great, and we appreciate all of you joining us here today. Let's give them a big round of applause.